Dear panelists, please confirm if I'm audible.
Yes.
Thank you. Good afternoon. Welcome to Japanese Law 101 webinar series at CIC, presented by AsiaWise. My name is Justin Jiang, an associate of AsiaWise Legal Japan, and I'm honored to be your host today. Before we begin, I'd like to ask you to kindly pay attention to the following during the webinar for the best viewing experience. To protect your privacy, please remain on mute and keep your camera off during the entire session. You may submit your comments and questions at any time using Zoom's built-in Q&A function. If you'd like to receive a copy of today's presentation material, please make sure to complete a survey at the end of the webinar. Now, please give a round of applause for Mr. Masaru Nagura, Director of CIC Japan, for a word of welcome. Mr. Nagura.
Thank you, Justin, and thank you everyone for joining this seminar. As you see, AsiaWise Legal webinar at CAC. This seminar was supposed to be at CAC, one of the largest innovation center in Japan. And I am the general manager of the CAC Tokyo, and happy to have you all with this seminar. So this seminar is very exciting all the time, and AsiaWise professionals with some guests, they will give you a great insights and knowledge for the Japanese laws. So please enjoy this seminar. Thank you.
Thank you, Nagura-san. We're excited for the collaboration and hope more is to come. Now, please welcome Mr. Kotaro Kubo, attorney at law and representative AsiaWise Legal Japan, for a brief welcoming address. Kubo-san.
Okay, yeah, first of all, thank you very much for your participation. We are pleased to welcome you for our second English webinar. Also, I think today is the first anniversary of CIC Japan and Tokyo. So congratulations for the first anniversary. I still recall that we entered CIC Tokyo as one of the early bird members, and time flies. It was so quick to see today's anniversary. And let me also introduce briefly AsiaWise Group and its member law firm in Japan. AsiaWise Group was established with 3 co-founders in 2019, 3 years ago, namely Nitin Wadhwa, my fellow colleague from India, and Yoshinori Oku, our IP team leader. And our AsiaWise concept is a cross-border professional firm from Asia. And currently, we have 10 Japanese qualified lawyers based out of Tokyo office. And we have been supporting both Japanese companies doing business outside Japan and also the non-Japanese foreign clients doing business in Japan. And speaking of today's topic, as you can see, the topic is the e-signature and contract law. So I understand after the COVID-19 started, the border was has been closed, and it becomes harder for businessmen to go beyond the borders. But still, businesses have to do the cross-border transactions, and we see more often that these cross-border activities are conducted on an online basis, and that's one of the reasons why we pick up this subject, e-signature. We, AsiaWise, want to support such a cross-border activity, especially by using the technology such as the e-signature. Thank you very much.
Thank you, Kubo-san. That's a good opener for today. And in today's seminar, like Kubo-san said, we'll take a look at contracts under Japanese law. First of all, a list of most frequently asked questions on entering into commercial agreements in Japan will be answered by Mukiko Ashiwa, our associate AsiaWise and attorney at law. Our other associate present today, Shogo Matsumura, attorney at law, will then walk you through the key issues concerning electronic contracts under Japanese law. We're also honored to have Mr. Jim Weisser, co-founder and CEO of SignTime, for his expertise on the current state and future development of e-signature services in Japan. Now, finally, we'll also host a panel discussion and answer any questions from you in the time remaining. Without further ado, let's kick off today's webinar with the fundamentals of Japanese contract law. Hashiwa-san.
Yeah, thank you, Justin. Thank you, Justin. I am Mugiko Ashiwa, an associate lawyer at AsiaWise Legal Japan. I joined AsiaWise 4 years ago after working as a judge for 2 years. During my session, I would like to talk about the basic points regarding executing the agreement with the Japanese companies. I pick up 7 questions which we are frequently asked by the international players when they execute an agreement with the Japanese companies. Please imagine that you are going to execute an agreement with the Japanese company. You might have the same questions as I prepare in this presentation. So let's go to the next slide. The first topic will be the validity of agreement. You may have heard that it is very common to use the company seal in Japan. So sometimes this question comes, would an agreement be valid under the Japanese law if it is executed by one party using a company seal and the other using a handwritten signature? Next slide, please. The simple answer to this question is yes, the agreement is legally valid if he or she is authorized to do so. Firstly, basically, even an oral agreement is legally binding. The reason to execute a written agreement is to make the terms and conditions be clear. You may have heard that the individuals and the companies tend to execute an important agreement with the registered seal. In Japan, generally, a registered seal is strictly controlled and affixed by only an authorized person. In addition, the Code of Civil Procedure states that the document is presumed to be genuine if the registered seal is on it. Therefore, when a registered seal is affixed, the authenticity of the document is legally presumed. This is the reason why the Japanese company tend to use a registered seal. Let's go to the next slide. The second topic will also validity of agreement. This is also a well-asked question by international players. At the time of executing an agreement, we are not sure if the agreement has been resolved by the Japanese company's board. The Japanese company told us that a board resolution would not be necessary, as its representative director will sign the agreement with full authority. Should we request the Japanese company to provide us with the minutes of the board meeting? Next slide, please. Of course, there are some types of the transactions required board meeting, such as share transfer agreement in case of M&A. Please assume this case is a daily operation matters. In that case, it is not necessary to request the minutes of the board meeting, nor confirm the existence of the board resolution on the specific agreement. Because under the Japanese Companies Act, the representative director had the authority to represent the company. In addition, if the company is large, then the board meeting is held only once in a month or like once in a 3 months. Therefore, the daily agreements do not subject to the board resolution. As conclusion, you may not need to confirm the board meeting for every case as long as the daily operational matters are concerned. Yes, let's go to the next slide. Now let's discuss about the detail of the agreement. I think both the Japanese company and the international players should be paying attention to the jurisdiction clause. The first question is, when negotiating the detail of an agreement, the Japanese company insists to have the Tokyo District Court as jurisdiction. Is it acceptable? Firstly, when considering jurisdiction, you should think about the enforcement of the judgment. Even if you win the case, the counterparty does not automatically pay you the money. You need to enforce the judgment. For example, you need to forcibly sell the properties of the counterparty under the legal process and collect the money from the sale proceeds. Therefore, in case of considering jurisdiction, you need to check if the judgment in the jurisdiction is enforceable in the location of the counterparty. The court does not automatically accept the orders by a foreign court, the legal system are different. In Japan, in the past court cases, in case of the judgment of China court, the Japanese court did not admit its enforcement in Japan. This means you will get nothing after all, even if you win the case. In order to avoid this confusion, we recommend resolving the dispute by arbitration, such as SIAC and JCAA. In case of the arbitration, the country or the counterparty is one of the parties to the New York Convention. The award of arbitration is enforceable in that country, and more than 150 countries are the party to the New York Convention. To answer to the question simply, even if you want to have a jurisdiction in your country, that may not be a good choice. It's better to consider arbitration. Yeah, let's go to the next slide. Yeah, next question is in relation to the governing law. We often come across a Japanese company requesting Japanese laws as the governing law. What do we need to know before accepting this agreement? Next slide, please. Yeah. Regarding the governing law, this may be subject to the power balance of the parties, and there is no concrete advice on this. Despite the dispute resolution clause should be more scrutinized more closely. If a jurisdiction in the Japanese law and the Japanese law, the governing law is non-Japanese law, you may need to submit the Japanese transaction of the governing law, but the Japanese court is still be able to handle such case. Okay, next slide, please. Next, many business are affected due to the COVID-19 situation. So the question is, does the concept of the force majeure exist under the Japanese law? Should one include a force majeure clause when entering into an agreement with the Japanese company? Next slide, please. Force majeure is defined in the Block Law Dictionary that an event or effect that can be neither anticipated nor controlled. Under the Japanese Civil Code, there is similar provision saying, for the failure to perform the obligation is due to the ground not attributed to the obligor in light of the contract or other sources of obligation and the common sense in the transaction, the creditor does not entitle claim compensation for loss or damage arising from the failure. Therefore, even if you fail to provide the force majeure clause in the agreement, if the governing law is Japanese, then you are protected to some extent. But since there is no clear definition of the force majeure under the Japanese Civil Code, it would be better if you list up the event to be recognized as a force majeure in the agreement. Next slide, please. Next, I would like to explain the definition of the damage under the Japanese law. The question is, we forgot to include a specific clause on the damage when executing an agreement governed by the Japanese law. Are we reliable for the damage in absence of the specific agreement? Are we reliable for the damage in the absence of the specific agreement? And to what extent do we need to cover the damage? If there is a breach of contract, a non-breaching party can claim ordinary damage even if there is no specific clause under the contract under the Japanese Civil Code. Also, a non-breaching party may also demand the compensation for the damage which arises from any special circumstance if the party did or should have foreseen such circumstances. For example, the damage arising from the broken product, the amount of the price will be recognized as a normal damage. Bankruptcy of the party suit after purchasing the broken product, such damage of the bankruptcy will be recognized as a special damage. So let's go to the next slide. The last question is in relation for stamp duty. Do we need to stamp duty for an agreement executed with a Japanese company? In Japan, a limited scope of the legal document requires stamp duty for execution. Next slide, please. For comparison in India, both types of documents require stamp duty, including power of attorney. But in Japan, only few documents require stamp duty. For example, agreements for transfer of real estate, patent rights, trademark, design rights, and service agreement called ukeokeyaku in Japanese. Also, as long as you do not exchange the document, namely written paper at the time of execution, you do not need to pay stamp duty. Therefore, as long as you use electronic signature, you don't need to pay stamp duty. So it is also cost advantage to use the electronic signature. And I guess this is a good introduction to pass the mic to Shogo and let my presentation end. Thank you.
Thank you, Ashiya-san. Thank you. That was a very good introduction on the FAQs we have from international companies wondering about contracts in Japan in general. And I'd like to say that you raised a very interesting question at the end there, electronic contracts. While they're proven to drastically simplify the business process, electronic contracts, they also pose a challenge to the traditional notion of contract under various laws, including the Japanese legal system. So how does Japanese law govern the practice of electronic contracts? What should one be aware of from a legal perspective on using electronic contract services in Japan? My colleague, like Ashiwa-san introduced, Shogo Matsumura, will be more than happy to provide his expert take on the subject. Matsumura-san.
Okay, thank you, Justin. Can you hear me?
Yes.
Thank you. My name is Shogo Matsumura, an associate lawyer of AsiaWise of Legal Japan. I appreciate your participation. In my presentation, I will give a brief explanation for the laws and regulations as to electronic contract in Japan. Please go to next slide. As an introduction, please look at the short case study in the slide. A Japanese company is looking to introduce an electronic contract service for the shift to remote working and COVID-19. And consequently, a few questions were raised by the legal department. Are electronic contracts legally valid under Japanese law? What is the formality requirement for the execution of a contract? Does stamp duty apply to the execution of electronic contracts? Are electronic contracts admissible in court as evidence? So I will go through these questions. Please go to next slide. First, as for the first question, it should be highlighted that in principle, no paper document required for the execution of a contract under Japanese law, because Section 522, paragraph 2 of Civil Code prescribes that, except as otherwise provided by other acts, the formation of contracts shall not require the preparation of any documents or the completion of any special formalities. But paper documents are necessary for some specific types of contract and document under applicable laws and regulations. For example, as you can see, in the field of real estate and property, some type of contract or document must be prepared on a paper basis. For example, such as 重要事項説明書, important points explanation of property to be sold or leased, based on Building Lots and Buildings Transaction Business Act. Having said that, the scope of such contract or document is very limited. Furthermore, it is expected that the government will begin allowing the execution of such types of contract electronically. And it is worth noting that, it is worth noting that most of contracts to be used in business, such as NDA, sales agreement, service agreement, license agreement, etc., can be executed in the form of electronic contract. Please go to next slide. Next, I will respond to the second question. Does stamp duty apply to the execution of electronic contracts? The answer is no. Stamp duty does not apply to the execution of electronic contracts. While stamp duty is required only for certain types of contract under Japanese law, as for electronic contracts, no stamp duty is required, regardless of the type of contract. Please next slide. Next part is to respond to the third question. Are electronic contracts admissible in court as evidence? The answer is yes. Electronic documents are generally admissible in court as evidence under the Code of Civil Procedure. Therefore, a party may submit an electronic document signed by an electronic signature or a digital signature to a court. The Code of Civil Procedure does not make a distinction between an electronic signature and a digital signature. In terms of electronic signature and digital signature, I will explain it in a next slide. To our understanding, no precedent on the legality of electronic document as evidence at this moment. Okay, please go to the next slide. As for the term of electronic signature and digital signature, please see the slide. Electronic signature or e-signature means electronic data attached to an electronic document as an alternative to a handwritten signature or seal. On the other hand, digital signature means a form of electronic signature that utilizes an asymmetric cryptographic system called public key infrastructure and the digital certificate in order to ensure the authenticity and the integrity of a document. Please go to the next slide. In Japan, Act on Electronic Signatures and Certification Business, generally called Electronic Signatures Act, defines the term of electronic signature. The Electronic Signatures Act does not make a distinction between an electronic signature and a digital signature. In this presentation, I will omit a detailed explanation for the definition of electronic signature. Okay, go to the next slide. The scope of electronic signature as provided in the Electronic Signatures Act is narrower than the scope of electronic signature when used as a general term. Even if an electronic signature put on a contract does not fulfill the requirement in the Electronic Signatures Act, the validity of the contract will not be affected. But in case of using an electronic signature for the minutes of board of directors meeting, it should be noted that such electronic signature must fulfill the requirement of the Electronic Signatures Act. Please go to next slide. Next, I will explain the outline of an electronic contract service. Please see the slide. Many electronic contract service providers furnish a service that parties can sign the contract on an email basis. The parties do not need to prepare a digital certificate by themselves and can complete the process of signing the contract only with email correspondence. To be specific, at first, party A, who intends to enter into a contract with party B, uploads the contract into the cloud provided by service provider C, and service provider C will put a digital signature with its digital certificate. Thereafter, an email to request acceptance of the contract will be sent to party B. Once party B clicks a button to accept the contract on the email, then the contract will be executed. That's all. This process is very simple and convenient, and this kind of electronic contract service recently becomes popular in Japan. And in 2020, Japanese government issued a notice to the effect that this type of electronic signature can be regarded as a valid electronic signature based on the Electronic Signatures Act. Please go to the next slide. In this slide, I would like to look back the answer to the questions raised in the introduction earlier. At first, are electronic contracts legally valid under Japanese law? The answer is yes. Electronic contracts are generally valid under Japanese law, so long as the general requirements for the validity of contracts are fulfilled. Second, does stamp duty apply to the execution of electronic contracts? The answer is no. Stamp duty is not required in a case of the execution of electronic contracts. Finally, electronic contracts admissible in court as evidence. Yes, electronic contracts are admissible in court as evidence. Next slide, please. As explained thus far, Japan has enacted the law regulating an electronic signature, namely the Electronic Signatures Act, in 2000, about 20 years ago. So the legal framework of electronic contracts already exists in Japan. However, for the last 20 years, we did not observe any significant changes in the contract practice, which is still dominated by papers. The COVID-19 may recently provide strong incentives to companies to introduce electronic contracts. And in my impression, many Japanese companies strive to introduce electronic contracts. But what about the actual practice? This question is the introduction for the next presentation provided by Jim-san. This is all for my presentation. Thank you for listening.
Thank you, Matsumura-san. Thank you for the presentation. Like you said, yes, electronic contracts, they should be flourishing in Japan, given the mix of a well-equipped legal system and the increasing demand coming out of the shift in working style. But is it actually the case in practice? How do industries in Japan view electronic contracts and signatures? Realistically speaking, can electronic contracts and e-signatures replace hanko and paper? To find out, please welcome Mr. Jim Weiser of SignTime for his insider take on the past, current, and future of electronic contracts and e-signatures in Japan. Jim.
Thanks, Justin. I appreciate the kind introduction, and I'm going to see if I can successfully do a screen share here, which always seems to be the challenge for when we're doing these remotely. One moment, please. There we go. Can you see that?
You got it. We can see it.
So let me start with a short introduction of myself. My name is Jim Weiser. I'm the CEO of SignTime KK. I grew up in Texas and have worked in the Japan internet since the mid-90s. So I actually predate the electronic signatures law in the time I've been in Japan. And I've founded 5 different companies, mainly in tech space. Some successful, some not. I'm the co-founder and CEO of SignTime KK, which I co-founded in 2020 with a friend and a true e-signature pioneer, Jonathan Siegel. He had founded a similar company in the United States in 2009 and sold it in 2014. We've jointly applied for patents related to e-signatures and physical devices, particularly as focused on the Japan market. I'm also a relatively active angel investor in, 15 to 20 companies, mainly within Japan, and mainly focused on DX or digital transformation, a judge in the Asia Entrepreneurship Awards, and have had the opportunity to meet with over 100 companies operating in Japan, foreign and domestic, to discuss DX and e-signature strategies. So the following slides are what I've learned. Take it as you will. I think the first question that people ask, why are we doing e-signatures in Japan generally? And to answer that, you start with why do e-signatures at all? The first is they're fast. If you look at e-signatures compared with typical paper-based contract, you can go from days to weeks to a few hours or even possibly a few minutes. And for those salespeople who are trying to close deals of certain sizes at the end of the quarter, that's a big deal. They're legal. We've gotten a great deep dive from the AsiaWise team on this so far today. And so they work in almost all cases, both internal to a company and externally. And they're secure. This is one of the most common questions I get asked, but while security is outside the range of the real details of our discussion today, there are a lot more details and a much better audit trail available with e-signatures and more control than paper, than fax, than email. And fundamentally, you don't have to worry about someone stealing your hanko or jitsuin and misrepresenting your company. So over the last 18 months, there's been a lot of great news, a lot of press about e-signatures, whether it's the market size growing big or the end of paper, so on and so forth, and stamping out the Hanko. Yet, as we've seen, we're not quite there yet. The Japan, based on some data that we pulled about 3 months ago, the Japanese white-collar workforce is about 30 million people, but yet the e-signature adoption rate is under 2%. Now, we think there are a number of reasons for that, but the most obvious one, which will surprise no one who's worked in Japan, is that Japan is different. Yeah, contracting in Japan is currently fax, paper, print, sign, scan, send. And I wrote fax, yes, fax, because when you talk to people from other countries, they're surprised that the fax machine even can still receive things. Japan, though, there's still a substantial amount of business in the world of fax. Now, when you start to look at doing e-signatures, I found very few people have actually seen them in action, much less touched and used them. So I thought I'd do a couple of simple screen shares that show what it looks like. What's happened here is a Word or a PDF document's been uploaded, and you just need to add the person's, the date, the address, and their signing authority, essentially. And with that, you're done. You can send it to someone with an email address for e-signature. Now, one thing that's a little bit different in Japan is that we found that having a Hanko function is required. Most Japanese people are not that comfortable with signing compared to with using a conventional Hanko, regardless of whether it's a Jitsuin or even just a personal Kojin one, or even if it's just a personal one. So now I'd like to move a little bit to talk about some specific customer experiences of the people that we've been talking with. I think these may be illustrative of the challenges that people run into. Yeah, so these excerpts are all from interviews that we've done either in person or over video with companies, and they're reasonably representative. So the first was with a very large trading company we went to visit. And we said, hey, we saw that your e-signature press release happened in 2015, 16, somewhere around there. How's that going? And we were talking with the Kikakubu, or the planning team people, and they said, well, we announced it, we used it for some international contracts, but the Gembo, or the frontline workers, didn't really like it. We found that's one of the most common issues that shows up when we're speaking with Japanese companies. We'll talk about that a little bit more later. Speaking of smaller real estate company, they were excited. It's young Shacho. He's very much into this sort of thing. He's gone as digital as he can, but he was like, we are interested in e-signatures, but we have to read the T's and C's in person, so we don't use them. That's the Juyo Jiko Setsumeisho that we mentioned earlier, where it's not legal to just have it electronically signed. That actually has to be done in person. A furniture design company we talked with, we haven't thought about e-signatures at all. So it was interesting to have that conversation, just see where they were at. But their view was that they were very focused on high-end design and high touch, and that e-signatures were more of a cost control issue. An insurance multinational that we spoke with, only client-facing things. Now, in most companies we've talked to, they've been much more comfortable with a slow start starting out inside the company. But in this case, it was more about doing contracts external to the company with them, policy management and so forth. One large manufacturer came back and said, hey, will e-signatures also be valid in China if we use them there? Well, we're not going to do a deep dive on that. I think today you saw that there are often issues with Japanese law versus Chinese law and what's enforceable where. And so e-signatures would just ride on top of the law at that point. It's not so much a matter of, is it an e-signature issue usually? It's more a matter of, is there a legal issue? And then a mid-sized university we're dealing with here said, hey, we use e-signatures for our contracts and applications. Can we integrate with our database? And so that was a big win for us, and we're actually working with them now. I'll speak more about that later. So the first on the Gemba, to anyone who's worked substantially in a Japanese company, you're familiar with this concept. It's really about making it easy for the end user, or historically Gemba was factory floor to use. The reasons that we see are kind of manifold, but they're predominantly cultural. In one one set of issues is that e-signature implementations look and feel very much like Western applications in most cases. They don't flow, they don't feel like a natural Japanese application. They won't show you a hanko on a Mitsumori show as it goes through an approval process, or hanko on Ringi show as it moves through. So it doesn't feel like a proper contract. It also doesn't feel as safe as or secure because it's electronic. Ironically, it's often more safe, more secure with better audit policies on it, but that's not how the end user feels. And then finally, one thing that comes up fairly frequently is there are other business processes that maybe should have been automated that aren't. And so there's some tension that goes into the frontline worker challenges as well. In real estate, we've seen that real estate was one of the early adopters in e-signature globally. Yet in Japan, it's very, very slim. One of the other feedback points we got beyond just the Juyo Jiko Setsumeisho, or the T's and C's, but actually signing is a ceremony. And there's a lot of paperwork and changes in associated with and to the ceremony. And so it was a matter of, we'll still probably do the big thing in person with a fancy pen or fancy paper and big celebration. But there are a lot of follow-ups that we want to get done before. There are a lot of follow-ups we would like to be able to do afterwards, small changes that need to go through, things need to get done before. And because of that, they're comfortable with it in concept, they're comfortable with it in lots of cases, but for a big deal, that they may still want to do it in person. We're fine with that, no issues there. In fact, if you see, I believe Shizuoka Bank, they do on-site e-signature work where they're electronically signing things, but in person. It's kind of an interesting hybrid experience, so they can avoid the taxes associated with doing it with paper. Now, this was a big win for us. It was a university who was trying to deal with a large number of contracts and also the applications that came in from their students. Some of their students are overseas, so they needed an effective way to make sure that all of those students had signed in and met their requirements, particularly as they're dealing with housing. They also have a fair number of adjunct or part-time professors and contractors. And so being able to integrate this into a smooth workflow for them was a big win. Additionally, some of the things that they needed to attach to these contracts were not just the signatures themselves, but also an ID, and sometimes even credit card information if a deposit was required. Because of some of the integrations that we've done, we enabled them to get the ID through with no issues, and for a credit card to go directly into their processor without ever saving the credit card number to improve security. They also historically had difficulty tracking responses with their current system, where they would just email a large number of people. And if they missed one, they would miss one. Eventually, they might find it, but it required a lot of manual work. And so the simple database integration led to hundreds of hours saved and better outcomes all the way around. Then in the is it okay for us category, we heard from a Japanese asset manager understanding how it would be legal in their industry, and also will e-signatures be valid in China? And so we basically said, look, there's some complications in certain industries and cases. And the financial services industry has a bunch of regulations with them already. Multi-jurisdictional contracts have issues to be resolved, whether or not they're done via e-signature, which the AsiaWise team is expert in already. So you've got a good resource that you can talk to as you look at developing the relationships between companies in China and in Japan. So in summary, most Japanese organizations really just view e-signatures as for external contracts only, rather than all signatures that you might need. So one of the things that we see as impeding growth to some degree is just to focus on, oh, this is only for external contracts. Yet there are employee contracts of things like receipt of the standard terms and conditions of employment, as those change and are updated, and other things as well that require a signature and require tracking within the company in human resources. Yet those are often handled through a separate system or very manually, often on paper. We believe at SignTime that there are cultural blockers which are at least as important as technological ones, whether it's foreign style workflows or a hanko requirement for it to feel right. Now, specific industry regulations have continued to impede process a bit, though several of the regulations since 2020 are being amended to allow for e-signatures, remote explanations, and so forth. I'm very positive on the state of legislation right now. It's very forward-looking, at least as what's been generally proposed publicly. And the total adoption rate of the market is very, very small. So much that I was willing to start a company around it last year. So with that, folks, thank you for your time. Yeah, and be happy to take any questions or whatever within the panel discussion that we'll be doing shortly. Thank you very much.
Thank you, Jim. Very insightful take on the state of e-signature in Japan. And I think we'll actually do that panel discussion session because I'm sure the audience have a bunch of questions they want to check with you on or check with our associates on. So coming off your know-how and our associate summaries, it's clear to us that this movement on policy level does not always translate directly into market growth or even market potential. Still, as I believe our audience today here, they all share a genuine interest in the Japanese tech market, if not contract law or e-signature per se. I'd like to invite all panelists today to further discuss the reasons behind this mismatch and perhaps enlighten us on the uniqueness of Japan's tech industry and business climate from their own perspectives. Now, before we begin, to keep the conversation as open as possible, we'd appreciate your active participation as audiences. Please, if anything crosses your mind, feel free to submit your comments and or questions to us using the Q&A or chat function. Now, let me just quickly pull up the slides. Okay. If I want to understand one thing and one thing only from today's session, it would probably be the mismatch between legislation and the industry. Let me first ask Kubo-san on this. Kubo-san, what's stopping Japanese companies from using e-signatures and electronic contracts in general?
Yeah, thank you, Justin. Jim already posed a very interesting question. Is Japan different? It reminds me that the Japanese people sometimes refer to Galapagos archipelago. You know, Galapagos is a small island in the Pacific Ocean where you can see the various different type of the creatures after the evolution, which happened generation after generation. If there is any such a Galapagos factor uniqueness in Japan in the sense contract practice, one of the reasons, of course, the hanko, as already explained by Jim, which is a company stamp, which has been habitually used in Japanese companies' daily life. But you may know that the hanko is originally not the Japanese culture, but the Chinese culture. We, Japan, introduced the hanko, I think about 2,000 years ago. And some Chinese emperors gave us, and we have been appreciating such hanko as the kind of a symbol of the authority. I think, this is long enough to appreciate it. That's one of the, cultural reasons. But if I add one more different reason why Japan is very slow to adopt the e-signature in the contract practice from the legal perspective is that the existence of representative director. As Mugiko Ashiwa-san explained, under the Japanese Companies Act, so long as the representative director says yes, that's executable by the company, you don't have to get the approval from the board. And so long as you use the hanko of a representative director, you don't have to go through the all the verification process whether this execution is valid in relation to the company's articles and the other internal documents. I think this is one of the other reasons from the legal perspective. So, yeah, answering Justin's question, based on the such historical or legal reasons, e-signature has not been so much, prevalent in Japan because you cannot use the president or representative director's signature by using e-signature too, and that also explains the reason why, as Jim said, hanko still survive the e-signature world.
Thank you, Kubo-san. I think that's a very, very professional take from a attorney, from a Japanese lawyer, especially the second point. And I do want to get more close on your point, but coming from Jim's perspective, being someone that's working closely in the Gemba, in the front lines. So Jim, have you observed the concerns as mentioned by Kubo-san? What's your take on the relatively low market adoption rate as of now?
Right. Well, I think Kubo-san's pretty much correct. Japan moves, but it often takes a while to move, and it tends to be more kaizen rather than abrupt. So it's continual change. And so I actually first looked at entering this market in 2018, but I couldn't see a reason why Japan would make this change. And so while I've lived in Japan for more than half my life and hope to live as long as a typical Japanese, I wasn't sure there would be business success in that time period if I started in 2018. With Corona, though, or COVID, there's a substantial reason to make changes. And in my experience with Japanese industry, once that reason exists and there's a clear reason to move forward, the things tend to move very slowly, then very quickly. I think right now we're in the very slowly stage. There are a lot of planning departments who are looking into this. People are doing diligence on the markets. But I think over the next 3, 4, 5 years, it will move. It won't be 2%. It'll be, I don't know, 15% or something. Yeah, I don't know. That's probably too optimistic, actually. But it will be a material change from where we're at. Yeah, and so I think also anytime that you change a process in a company, it's hard. And Japan often has very, very detailed processes compared to most other countries. So trying to take that and apply that to a digital environment may take more development or more computer work than it might take other places as well. So did that answer your question, Justin?
Yeah, thank you. I do think this inertia to preserve traditions, or just simply desire to not change, desire to maintain things, definitely gave rise to Japan being called late by many experts on entering the digital era. Some say that the digital era in Japan didn't begin until the late 2010s. And according to your answer, you think that the window wasn't open until COVID hit last year, or 2 years ago. Wow, that's crazy. 2 years ago. So I do want to have a follow-up with you on this, Jim. You mentioned Hanko. It's ESignature's biggest competitor. We know that they've been the predominant means of authentication and personal representation in Japan for the past 2,000 years, according to Kubo-san. What are the main challenges in trying to raise such an innovative and alternative solution to a long-standing practice?
Well, I think, Justin, it's really what both Kubo-san and I have talked about. It's adoption. It's convincing people that what you're doing is better. And historically, with Japan over the last 20 odd years being in deflation, it's hard to get people to justify spending money for something that's not obviously going to reduce cost or increase the top line. And in my case, it obviously saves quite a bit on the personnel side of things. It also provides for better document retention security. But that's often not enough within a cultural context to make what's considered a large change.
So thank you. Despite the sort of catalyst being the COVID moving into the way, you still see that Japan would be slow to react when it comes to adopting changes of this scale.
Oh, I'm sorry, I didn't phrase that quite correctly. I thought you meant pre-COVID. No, I think COVID's the catalyst. I think we're seeing what I view as level 1 digital transformation, which is taking atom-based processes and turning them into bit-based processes right now in Japan. We've talked about it for a while, but it's actually moving now. And the COVID thing and remote work as well has moved to where this has become more of a required concept than an optional concept.
Thank you. I think COVID actually demonstrated that, at least from my observation, that more and more Japanese companies are at least considering for adoption of new technologies and embracing a digital way of doing business. I've encountered less and less faxing and paper documents in my day-to-day work, for example. Now, I want to steer the question into Kubo-san and ask Kubo-san that as a Japanese lawyer, how does this conservatism towards change amongst Japanese companies translate into the legal side of things, such as contract negotiation and compliance?
Legal, yeah. I think your question is valid because generally Japan is very slow to adopt the new technology and especially in this digital technology. But I would say legal and the compliance department is one of the slowest departments among the various functions of the company. And yeah, we seldomly see the introduction of the legal tech. You can call the technology in a legal field legal tech. We couldn't see that, but recently you can see some various legal tech tools, and they are very slow and frustrating. But some of the Japanese early bird companies start adapting such legal tech tools. And today's topic, e-signature, can be one of them. And I think one of the easiest for the Japanese company's legal department to take, because I heard from Jim that the Gemba frontline may become the obstacle to introduce such a new technology. But this tool, e-signature, is very much helpful for the Gemba frontline workforce. You don't have to go through all the or paper contract paper execution process, and you can also enjoy the reduction of the cost. That's also very beneficial for the companies. And one more thing is this will resolve the pain of the decision maker. For example, last year, 2020, when we had the study session with some of the managers of the legal department, they complained that they had to go to their company, although their subordinates didn't have to go to their company's office because they have to put their hanko as the manager. But once you introduce the e-signature system, managers don't have to go to the office anymore just for the purpose of putting a hanko. This is the clear example of the resolution of the pain. So I think this can be a very good kickstart. And once you introduce the e-signature tools, that means the entire contract negotiation and the execution process can be digitalized. So after that, you can also introduce the AI review tool or the contract life cycle management, CLM, etc., etc. So I am, in a sense, optimistic, even though the Japanese legal department are very slow to adapt, but this e-signature can be a very good start.
Thank you, Kubo-san. We received 2 questions from the audience. I think I'm going to start with the more technical one for Jim. Is it not possible just to use a hanko for e-signature instead of a digital name signature? Could you maybe provide an answer to that one?
Well, sure. Actually, Kubo-san's probably the correct person to answer this because he or one of the group presented earlier that oral agreements are effective legally in Japan. So certainly, any mark that indicates that you agree would be fine with that. I'm not certain if it's a hanko as compared with signing, looking. What's the right way to say it? If what Robert means is uploaded file, can you upload a hanko instead of uploading your own personal signature? Yes. Yeah, there's nothing wrong with that. And yeah, we see people doing that. The challenge that you run into is once you're up to what Kubo-san was speaking about with the registered company seal for the representative director, my understanding, and Kubo-san, correct me if I'm wrong on this, is that you need to follow many more rules in terms of authentication than you need to do to assume that it's on behalf of the company, than you would need to do with just the image file. Would you like to clarify that one, Kubo-san?
Yes, you are correct. I don't have to add anything.
Thank you both. The other question, I guess only Jim can answer this now. What's the cost of having an e-signature system in a company?
So like anything, it falls in the it depends category, but it runs as low as 900 yen per month, or what it's $8 US or something like that monthly. There are some companies that do free stuff to thousands, tens of thousands, hundreds of thousands of dollars per month, per year. What happens basically is many companies start out with a seat-based pricing model, but then it pretty quickly moves to a how many contracts are you sending model. One thing that I would say, my own personal view on how the market's developed, and one of the other impediments to depth of change in Japan, is when you have incremental price changes for things in Japan, the adoption rate is much, much slower. Because I saw this when I first got here with software, where people would share one floppy disk. Okay, I guess I'm dating myself with floppy disks, but anyway, but they'd pass one floppy disk around the office to use a program rather than just buying it for the whole office. So the cost control mindset certainly dates back as long as I've been here. And that shows up sometimes with people saying, well, maybe I can share with Justin. It's like, well, maybe you don't want groups being able to send out contracts and sign things for each other, but it depends on the group. It depends on what they're doing. We see some some people who run just their internal purchase requests with this, they're fine using groups. So that's good. Kind of a long answer. Sorry.
No, thank you for providing the details, Jim. Robert, I hope that answers your question. And as we're approaching the time of our seminar today, I'd like to once again thank Jim and Kubo-san, Matsumura-san, Shio-san for speaking, presenting, giving us information. And before I leave the floor to Ms. Mikako Suzuki, event lead at CIC Japan, for a brief introduction of her organization. Suzuki-san.
Hi. Yes, thank you, Kubo-san, Shio-san, Justin, Jim, and Matsumura-san for today's session, because we see in Japan we're lacking English business information tremendously. And at CIC Tokyo, we support entrepreneurs here in Tokyo. We also have internationals entrepreneur, and we're so grateful that AsiaWise organized this tonight, and hopefully it was really helpful for all the viewers today. And so last 2 minutes, let me introduce a little bit about CIC Tokyo. So in the very beginning, Masaru has introduced a little bit about us. So we are a share office in Toranomon area. We organize community for entrepreneurs. It's directly connected to Toranomon station, 2 lines. So it's really easy for access. As a global group, we have 20 cities across 11 cities. 20 sites across 11 cities. And CIC Tokyo is the newest, which was launched last year. And AsiaWise joined us as one of the first company last year as well. This is some of our office space. We got a co-working space and also private office, and some different conference rooms, event spaces, and some wellness area, which is all inclusive in the office price. So let me introduce quickly how, for example, AsiaWise plays role in our community. So as you can see, we have different partners and also stakeholders around entrepreneurs, startups. And for example, AsiaWise is in the category of professional firms who can support any industries, entrepreneurs. And we all exist under one roof. So you can talk to them really easily. It's a fast communication. So CIC is a hub for entrepreneurs and also all the supporters around them. So I just like to say, if anybody who's interested in looking at CIC offices or any other events, please check out our website, event pages. Hopefully we will see you there as well. So thank you for this time.
Thank you, Suzuki-san. Thank you, Suzuki-san. Thank you. Let me just quickly pull up our thank you page because that's very important. Well, thank you. I want to thank everyone for attending our session today. And as Suzuki-san introduced, CIC brings inspirations to us, to future entrepreneurs, more importantly. And that's actually a part of our goal at AsiaWise, where we were provided the opportunity with CIC to bring inspirations and invite successful entrepreneurs, inspiring entrepreneurs like Jim himself, and help businesses to sort of achieve success in Japan. And I'd like to thank everyone for the opportunity, and I'd like to thank everyone for attending the seminar today. And I hope everyone got to take home something from today's event. If you wish to receive a copy of today's presentation slides, please complete the survey when you exit the meeting room. Finally, I'd like to say that AsiaWise, along with CIC and expert guest speakers, we will continue to host Japanese law seminars in English to support your growth. Please stay tuned for more information from us and CIC. Thank you for your attendance, and until next time.
Thank you.
Thank you, everyone. I appreciate it. I'm also happy to get email from any of you with more questions.